gonna take my blood up and then he get to keep it. That's not racist. That's not racist.
Thinking about little bro, my mom. I was just thinking about you.
I don't see where she was waiting for.
Parker's in the back corner.
Yeah, she said she wasn't here before. I'll sit down and contact him on the trial dates.
Whatever day I shot in that email, so I'm good with what you guys want to throw out there.
Okay. Did points at the time saying you'd be happy?
I don't recall getting one.
Still ugly. Nigga ain't got extensions no more.
Nah, that's all him.
Nigga got real hair, you know. Women hair there. Dirty up, perky up. I don't care about what's Oh no.
All right, you put Buck Hughes out there, I'll get it today.
Good morning, everyone. How are you seated? All right. Where are we starting? We're going to start with resolutions. Okay. Paul Abercrombie, C 378091.
Good morning, Your Honor. David Lopez, ready for 120 on behalf of the President of the State.
All right, this was on for a status check restitution. I did receive documents from the state indicating a receipt from Paul Mortuary for $10,595. It appears as though victims of crime paid $5,000, leaving that $5,595 to be received to the victims.
That's correct.
What's
So
your
there
position?
I'm sorry, so speaking with Mr. Pesci, I think the request is for 5693.
Okay. What's your position on that
We're
5693?
okay with that.
Okay, so we will, at this point, add to the judgment of conviction, which has not been filed yet, $5,693 in restitution to Keontae McCary, QIANTAS, MCCAR. Anything else in this matter?
And just so the court is aware, there's some personal property of Mr. Abercrombie's that the police impounded.
Okay.
And I haven't spoken with Mr. Pesci about it, but I'll submit a supervision order, or if I need to, then I'll file a motion to try to get some of that. It's his personal computer, and try to get that back on.
Sounds good. If there's an agreement, you can just submit that directly to the DC2 inbox. If not, like you said, you're not counted.
Great.
All right. Thank you, Mr. Abercrombie. Page 11, Certificarian C 312718. He's present in custody with Mr. Coffey and Mr. Palal and Mr. Cuccinelli for the state. This is on for a motion to dismiss for violation of speedy trial, Sixth Amendment right to speedy trial, speedy trial rights. Mr. Coffey, did you want to be heard on your motion?
Just briefly, Judge, there are obviously two different rights at play here. There's the state speedy trial right, which was waived by virtue of the waiver included in the writ. There is also, of course, a federal speedy trial right.
Right.
If the court looked at the old minutes, particularly the first few appearances in front of Cathart, there was some massive confusion about what was going on, how the case was being filed. There were two separate cases filed. It was filed as an indictment, and then it was filed as an information also. There was a confusion about whether the state was going to elect one or the other. The election didn't take place until about a year ago, I believe, so it took a long time for the state to figure out which way they were going to do. At that initial appearance, the reason that I bring it up is despite the writ being filed, Mr. Michelarian was adamant that he wanted a speedy trial, that he wanted to move forward. And what was said from the bench, not by this court, was essentially, don't worry, we are preserving things, filing a writ doesn't mean that you're filing it in the other, that you're waiving in the other, and there appears to be some ongoing confusion. After that, there are continuances and continuances and continuances and continuances. And I'm not going to belabor the state's response. I don't disagree with a lot of it as to who those continuances are attributable to. Although I think a very large portion of those are attributable to Mr. Michelarian's counsel. There were things like the commitment to Stein and the Lakes, those kind of things that delayed things along the way. The state did seek at least one continuance along the way. If you look at the federal speedy trial factors, they haven't really changed much since the early 70s with Barker versus Wingo. The first thing is the length of the delay, and some of the federal courts have said that there's a presumption that a delay is prejudicial if it is more than a year. Just a presumption, it's rebuttable, obviously. But clearly you're more than a year. Here we are 8 years into this game. We took over the case about a year ago, give or take. So we have to look at the other factors. the reasons for the delay, the assertion of the rights, and whether or not there's actual prejudice. The reason for the delay, again, a lot of it has to do with litigation, and Mr. McTarian appears to be a party to much of that, but also some of it was state litigation, changing counsel, conflict, those sorts of things. So I think when you attribute all those delays, if you look at what you can take out, and I've looked at a number of the federal cases where they look point by point by point for each delay, and they will say this is attributable to the defense, this is not attributable to the defense. But even if you take everything attributable to the defense and to the mental health concerns where they're concerning Mr. McTarian, I think we're outside the year on that. So I think there is a presumption that way. The state makes an interesting point concerning the evidence, and is essentially that there is no prejudice involved because this is on video. And I won't say that I take a different position than that necessarily, but there are always witnesses that could be interviewed or followed up, and we are 8 years into this. Mr. McTarian has been in custody that entire time, wanting to go forward. So for that reason, based on his urging and to protect the record, we filed this motion to dismiss the violation of speedy trial rights, specifically the federal speedy trial right pursuant to Baker v.
Thank you so much, Mr. Coffey. I believe Mr. Puccioni, do you want to argue further?
Yes, Your Honor, thank you. So I mean, even if we let's take it step by step. What is attributable to the state? What is attributable to the defense? That outlined in the motion, there's only one really delay that can be attributable to the state. That was the loan motion to continue. I actually did the calculation. So that was filed slightly before October 29th of 2018. That was the trial date. That continued the trial date to February 19th of 2019. So that would be 113 days. That pales in comparison to the 8+ continuances requested by the defense. Now, it's unequivocal that he waived his statutory 60 days of trial right. I mean, that was in the writ, that can't be controverted. But looking at all of the analysis in the speedy trial, the four-factor analysis, yes, this case has taken a long time, but I mean, other than, conceivably, even if you take it all as gospel, we give them 113 days. That does not amount to any type of speedy trial violation. The case law I cited in here said, well, a 2.5 to 3 year delay on the part of the state because their case agent wasn't available. That's actually a good cause. So if the delay is caused by the state, but there's good cause, that doesn't go towards, that doesn't strike in the defendant's favor. Okay? So when we look at all of that, even if we're generous and we look at the 113 days that the state conceivably caused, I mean, I don't think that rises to the level of a speedy trial violation. And again, I know I outlined this in my motion, but I bring it up again because, I mean, they're saying, well, he was invoked the whole time, he wanted to go. This wasn't brought up until almost 8 years later. I mean, you can't sit there and say, okay, no, we're operating under the pretense that, we're no longer invoked, we're getting ready for trial, we're litigating, we're doing all of this. Oh, no, wait, actually we were invoked, we meant to be invoked the whole time. So, all these delays, all these continuances that we caused, that's attributable to the state. That's a basis for a speedy trial violation. I mean, that as a proposition I think is absurd, and I don't think the United States Supreme Court's jurisprudence on Doggett and Barker would support that. So, if Your Honor has any questions on the opposition, I'll submit on that. But I think even at a very generous view of the procedural history of this, looking at, okay, let's say for a second, the 113-day delay is attributable to the state, which I'm not conceding it is, but even under, if we take, even if we concede that first, even if we assume arguendo that that's the case, I don't think even that rises to the level of speedy trial violation.
Mr. Coffey, did you want a final word?
Just 2 points. It's not a comparative analysis. It's not whether the defense caused a longer portion of delay than the state. It's what's attributable to the defense. Defense could cause a very long delay and the state could still violate speedy trial and cause less. That's just not how it works. The other thing is there's ongoing confusion, ongoing disagreement between Mr. McTarian and his lawyers. He has mentioned speedy trial along the way at various points. The lawyers have always said we can't move forward, we can't go because, for example, we have to commit to Lakes Crossing this side. We can't go because of this. So that Mr. Mkhitaryan maintains that he has personally asked in court multiple times for speedy trial. And that's not happening. The attorneys have done something different, something contrary to Mr. Mkhitaryan's wishes. I know Mr. Mkhitaryan wanted me to bring up one other point. I missed it beforehand, and I apologize for that, Mr. Mkhitaryan. And that concerns something that is potentially missing, and that has to do with extradition from Panama. There was a request for Panamanian records a long time ago. I know Mr. Madu has told me he will try to provide the correspondence that are back and forth between Nevada authorities and Panamanian authorities, but we do not have that in hand as of yet. I would ask that that be produced at some point so I can provide that to Mr. Mkhitaryan.
Anything further, Mr. Coffey?
Court's indulgent. Come up, one minute. I'll bring that up just in a moment. The other thing Mr. Mkhitaryan wanted me to put on the record just real briefly is there was another comment from Mr. Kephart at the bench that the state would have a few weeks to elect whether to proceed underneath an indictment or information. That didn't happen for several years. Because of that, he thinks that one or the other should be stricken. We'll submit that to the court's discretion, but he wanted to place that on the record for sure.
Okay, and I think we've already dealt with that issue previously. I know you're coming in a little later, but I've dealt with a couple of these issues multiple times and have a lot of familiarity with them. I agree with you, Mr. Coffey, that the case does have a confusing history, and I agree that it is very old. It's my second oldest case behind another one of yours. But here, when I look at the record, the defendant did waive his statutory right to a speedy trial by filing that pretrial writ of habeas corpus and not asserting on the record for approximately 8 years that he wanted a speedy trial. I understand he might have told his attorneys, but we're looking at a defense team, and so the record shows a majority of the continuances, almost all of them being all of them are agreed to, if not caused by the defense in this situation. When I look at his federal right to a speedy trial, I consider the Doggett and Barker factors, and I find that they do not weigh in favor of dismissal. While the case has taken an extraordinarily long time to get to trial, many delays are due to competency proceedings as well as COVID, and then the vast majority of the continuances were attributable to the defense team as a whole, save for one continuance by the state that the defense did consent to, and that adds up to a mere 113 days of this 8+ year delay that we're looking at. While there may be some prejudice to the defendant by witnesses fading memories, ultimately this was a case where there were always going to be memory issues for a lot of the people that were involved due to the alcohol consumption. And this prejudice, I agree, I have to look at the defense prejudice individually, but I think it's shared amongst all the parties. Ultimately, this is a case that would have done better for both sides if it had been able to get the trial sooner. But it ultimately would be against the case law to dismiss and against the balancing test for the defense. Ultimately, most of the continuances are attributable to the defense for 8 years. I can't allow him to benefit by the dismissal at this point. And so I'm going to deny the motion, and I will ask the state to prepare the order.
One other thing, please, on the record, just briefly. I did review some law review articles before coming in for the argument. There has been at least a pitch academically that the assertion of speedy trial rights shouldn't be a fact that this court is inconsistency. We would ask the court to disregard that fact. We understand what the ruling is going to be, but we want on the record.
And so I think ultimately, as you pointed out, we're talking about two separate issues. There's the statutory right, which has been waived by that finally, it's mandatory that you wait in order to get the writ filed and heard. Secondarily, I think they could waive those factors individually without considering what he necessarily had.
Your Honor, if I may, please, I don't mean any disrespect for your courtroom or to yourself, but the information presented that I presented to the counsel with previous former counsel motions of speech up, and what I've provided myself is lacking in their argument and their motion. The information presented to the courtroom is not accurate. And so for the last time, and this will probably be my last time I make a record, and but I need to make a record of what my points are and what really took place in this proceedings and what was said from the judges and the orders given from the judges and how I did not waive or
Mr. McTernan,
Yeah.
if there is something that you want to file, you can submit that through your attorney, but ultimately he
I
does have to speak.
didn't have the opportunity in the Young hearing to have the Young hearing because I was unprepared and because I didn't have the motion.
We can do it again if that's something you'd like, but I'm saying, at this point, you are represented by counsel, and so you can't make independent representations from what your counsel's representing.
No, I'm not, but I do want to make the record, and this will be the last time. If you could allow me a few minutes to actually read what I want to get on the record, and I'm going to ask Alice
Hang on
Well
one
from the
second.
record.
Mr. Coffey, what's your position regarding that? Is that something that you want
My-
to do, or is that against your advice?
Well, it's certainly against my advice. That said, Mr. McTernan has free will. He is somewhat cantankerous, for lack of a better description, and dogged as far as wanting to make his points on the record. So he knows it's against my advice, but if he wants to make a record, I wouldn't stop him.
Thank you.
Okay.
And I don't think, the correct determination to be made unless the record is preserved or the correct information is brought before you.
Okay.
So I don't mean no disrespect to anybody, but this is just for my own comfort. And I need to make just a complete record of the entire proceedings and what my arguments have been and the reasons of what has taken place. And after that, I'm actually done
Go
with
ahead.
everything else. Thank you. Your Honor, I don't recognize the legitimacy of those charges or charging documents. They are deficient, having no legal standing / authority to hold me in custody or continue with the proceedings. I'm being detained unlawfully. Those charging documents are deficient and violated to my rights in the manner they seek the indictment, grieving lesser charges, which is unlawful for someone extradited under a single charge. An individual can only be charged with and tried with what he was originally extradited for. This is Roger versus United States. The state abused the process and procedures on how they elected to proceed by their measure of choices, only to raise bail. A record has been made with most of the issues in arguing the habeas corpus motion. However, I'm challenging those rulings due to the integrity of those entire proceedings, but explicitly when I'm intentionally lied to, deceived by the presiding judge / counsel, who on record during arraignment, February 22 of 2016, on page 31 states that an election was made and the state is proceeding to prosecute with the information. This is the order from the judge. The question here is, why would a judge say such a thing on record? This statement alone challenges the integrity of the proceedings from the beginning and the consolidation of the two cases. Further, should overarch any argument or excuse to the speedy trial rights. Current might 32 at the bottom, the court states, okay, sir, I'm going to, and on your behalf, I'm going to go ahead and set trial within 60 days on the matter. Continued on page 33, understanding that these are running, although they are two different cases, they're running at the same time, and the fact with regards to the indictment may have no impact whatsoever on their filing a writ on your speedy trial rights to the information. Counsel excludes a very important word here, whatsoever. So this was done to their knowledge of my refusal to continue with the proceedings and would not allow a writ to be filed, understanding the effect it would have on my speedy trial rights. Moreover, that my rights were being violated, unless it was normalized and an election made, will not proceed with any of the court proceedings, which is why my counsel asked for a court indulgence, and afterwards the court states on page 31, okay, Mr. Figler, with respect to C-3-12718, the murder itself, which was elected by the state, they're proceeding on that. That's my question. Is he invoking on that one then? Again, this entire ruling by Judge Kephart, who along to ensure my confinement. This is a fact. There's paper trail of a lawsuit which was filed by my family, which later they dismissed due to intimidation tactics, and these communications are well recorded. And so if the presiding judge took unlawful action without any authority to transfer my bail amount into Mr. Goodman's trust account to embezzle, speaks volumes on his rulings and integrity of to seek out a defendant in their duty to bring him to trial. Judge Kephart agrees, stating on record in February 2016-2017, page 29, line 22-25, so they may be successful on both of them on the writ. Then yes, I agree that they have to decide, and therefore I'm giving them 2 weeks to determine. And obviously they can only try the which one they want to choose. Also on October 12th of 2022, Ms. Mendoza stated on the 2 cases will eventually be dismissed. One of the 2 cases will eventually be dismissed. And to add, counsel avoids to insert where on March 5, 2018, the court noted it would be the last continuance. Even though the state had declared ready on March 20 of 2018, when it opposed defendant's motion to continue trial, they filed a second supplement notice of expert witnesses on October 5th of 2018, and 3 days later filed a motion to continue trial. So why does counsel elude such important factors? And I brought all this information to their attention. They're biased, and I've already made this a part of the record. Your Honor, the state disobeyed orders to make a determination on electing the case, which they would prosecute with, failing to prosecute due to their choices of non-electing, which would override any other excuse they may come up with. Since it impairs defense, 2 cases are very different, and a defendant does not need to defend himself on 2 different occasions for the same matter. On what I was placed in notice for and how it was pled. One murder charge was for a first-degree murder charge only, and the other an open murder with including lesser charges. So not only did it impair informing and prepare for a trial, but prejudicial due to the delay and the vindictive prosecution. Further counsels weren't hired to represent me in 2 cases. The district attorney was given 2 weeks to make a determination, and state, with complete disregard to procedures, abusing the process, orders withholding discovery and Brady material until now, till date, and the fundamental rights of a pretrial detainee, turned 2 weeks into 8 years until seeking to consolidate, and only because I was pushing former counsel to file with the federal courts for review. And state, well aware of my intentions, complaints which again I've documented with the court clerk, district attorney filed to consolidate, knowing that a reviewing court would dismiss one of the cases due to intentional disregard to the law or rights, and that dismissal would have barred further prosecution on the murder charge. And essentially, timing makes a case against the state's duty to bring a defendant to trial. A defendant has no duty to bring himself to trial. The state has that duty, as well as ensuring that the trial is consistent with due process. And so the district attorney failed to proceed in prosecuting this case. Also, the pretrial delay possesses a prejudice to the accused that intensifies over time, and prejudice attaches after 1 year. Doggett versus Baker. More importantly, actual prejudice from delay, Your Honors, which counsel again avoids to mention, is one key witness has passed away, and another can't be located, and the memory doesn't improve over time in Doggett. Your Honor, the court held that 1 year delay was sufficient as a threshold to mark the point at which courts deemed delay unreasonable enough to trigger the Barker inquiry. Moreover, in Doggett, the defendant was arrested 8 years after his indictment. The court found that the delay was presumptively prejudicial, noting that the 1 year threshold, that the government was negligent in seeking him out. Here, the state was beyond negligent in the manner of their choices. Most of Doggett analysis is geared towards prejudice, even though Doggett was not subject to pretrial detention because he was unaware of the charges. Unlike me, who was actually unlawfully arrested and kidnapped to the United States, violating my Fourth Amendment, due process, Federal Kidnapping Act, and international law. And to this point, I've raised my constitutional rights of not being tried within this court because of the illegal detention and return from to the United States. In response, Judge Kephart states on February 16 of 2017 at page 120, line 18, only if the United States was involved in that, he cannot be tried within this court. And Your Honor, this question still remains, and the motion with its arguments must be fully presented before the court for a ruling before we can proceed with trial, because I believe I'm detained unlawfully for now nearly 9 years, following despite posting bail after it was said. Bail was raised every time I posted bail, violation of my constitutional rights. But one particular occurrence, which I don't imagine has happened anywhere else, and state is still avoiding to justify its actions on record, is while posting a $1.5 million bail, the jail informed my family it was raised again by $1 million, and again without due process, without presentation of arguments and a motion, or even having a court appearance in court for a bail hearing. This intensifies my arguments of being held illegally when charges have been out on bail. But throughout the proceedings, state has done prejudice and keep me in custody in order to build a case and impair my defense. The record clearly displays that by district attorneys, judges, and ineffective counsels with their actions, there's fraud, deceit, corruption, and how my civil rights are affected, and the same is with my medical. For example, this court executed an order on August 8 of 2023 to transport me to my own doctor, and till date that order is intentionally not honored. It's been a year from now. Your Honor, I don't feel that I could get a fair trial at this point because of this sort of strange animosity by all parties due to their overzealous and improper pursuit of keeping me in custody. So in not recognizing the charging documents, having no legal standing, or that I could even be tried in this courtroom, the state has exceeded their authority along with all parties in regards to the pursuit of justice. And just briefly, in regards to discovery/Brady material, which was ruled by Judge Kephart in 2017, an itemized list of discovery was to be turned over to defense that they intend to use at trial, including audio, video, notes, warrants, etc. Until date, I have nothing. One in particular was discovery for my illegal return to the United States from Panama in connection with Metro and District Attorney through Giglio is on the hook for what Metro has. Your Honor, till date, that has not been turned over to allow defense to explore the issue of my illegal return. When recently questioning Mr. Coffey in regards to the discovery, he stated, I don't think we'll ever get that, and would ask the court to assist me in regards to this discovery and overall Brady material to be given to defense. Further, till date, don't know what discovery has been turned over from this order, since it has all been withheld from me. On February, which has delayed the investigation and hindered defense to proceed with trial. Counsel has done the same with not subpoenaing discovery to be used in my defense, as I requested. On February 16 of 2017, page 123 through 27, Judge Kephart states, okay, well, for the purpose of this trial here, if you intend to use any information involving going to Panama, that type of thing, I'm going to order that it be revealed, page 123, line 5 through 9. Then on page 127, line 20 to 23, adds that in this particular case, I'm just going to add, maintain whatever documents that they have to obtain in this case, be it from another country. These orders have deliberately been disobeyed, which impaired my defense, or worse, counsels have been intentionally ineffective in providing it. And I recently provided counsel with former counsel's letter, which he admits in not showing me the video of events for nearly 7 years. That in itself has impaired my defense, which I've also documented with the court clerk, that sending me to competency was how they held me from aiding my defense or getting discovery or making the record. Additionally, since the onset of the proceedings, despite my many requests, not only state but all counsels have been ineffective. Again, I've made a record with the court clerks with my letters/motions. Further, since the onset of this case, I have asked counsel to hold an evidentiary hearing in order for state to provide the identity of persons. Only former counsel, Mr. Figler, made the record on February 16 of 2017, page 42. He states, but the prima facie case has to address the elements, and so not only the premeditation and deliberation, but also intent, none of which were established by the witnesses that they presented. And so in the absence of that, like all 100 years corpus delicti cases, you certainly have to have that threshold, irrespective of when you want to call something open murder or you want to look at the elements that were actually pled in the information, the elements that are set forth to put us on notice to be sufficient. And none of that was done in regards to the preliminary hearing representation, and that's why the information should have been dismissed. Continued on page 46, he states, quite frankly, I don't believe that they established that Mr. McIterian caused the puncture wound, despite the very weak circumstantial evidence that they presented. That evidence is so circumstantial that we believe that even on the element of identity of a person, that they were unable to show by slight or marginal evidence that it was Mr. McIterian. So we have this entire cadron of sufficient evidence that impacts all these various elements. Again, by state's election, they had everyone under subpoena. Your Honor, the delay to this point, along with my illegal detention, should suppress and void all evidence to this point. Lastly, Your Honor, this case is so convoluted, tortured due to the ineffective counsels and the prejudice operation that it can't be tried because I can't possibly get a fair trial at this juncture. This case is such a mess from the beginning and defective from the start, and despite of my many attempts to normalize the proceedings to no avail, and now with it being consolidated, there is no correcting the proceedings because of the deficient charging documents, fraud and deceiving statements made by Judge Kephart that the state had cases when an election was already made in 2016, according to Judge Kephart's statement, along with an deficient indictment due to the lesser charges and the manner of the procedure and how they proceeded, process without the marking notice, etc., all to raise bail. And to make it worse, their non-election disobeying orders, not turning over discovery, etc. for nearly 9 years. Your Honor, these have been most of my conflict with counsels, the courts, who have allowed and aided the district attorney to continue with such prejudice proceedings, knowing this from the start that my funds were embezzled, my rights violated, and what district attorney has and is doing is wrong, without any authority. Can't imagine anyone in this courtroom would have tolerated the same treatment, or would approve if it was done to them for this long. Everyone would want an unbiased proceeding, rulings with adequate representation, and a fair trial. Also to mention, the gentle former counsel filed motion which I read the record of, moreover without authority due to me requesting him not to act as counsel unless a new retainer was signed, due to counsel changing the firm's name years before. In closing, I refuse to participate with any further proceedings and in aiding with the defense unless, and this is even a maybe, because again, I don't think I can have a fair trial at this juncture. However, unless these argued on in the United States Supreme Court, since having exhausted the state remedies, which I believe is biased when refusing to rule on questions of law, Your Honor, I believe there is plenty within this case and proceedings to get us to the United States Supreme Court, and counsels refusing to file whatever motion to be it the habeas corpus or curatory to challenge the proceedings / jurisdiction and my illegal detention for my release is improper, and I'm being forced to be held in custody. Also note, there is a filed lawsuit in regards to this case in the federal court currently. And that's it. Thank you.
All right, thank you, Mr. McTay. I understand you probably need to put that on the record. For the record, I've only considered what was before me in ruling on this motion. I was aware of almost all of those facts because you brought them up to my attention before, and because of Mr. Gentile's addictive prosecution motion that we had already heard. But just to be clear, today I've only ruled
Supreme Court, pre-trial, Mr. Secretary, I've had that discussion with you before. Legal opinions on the record, you can take me up on it later and call me in fact. In regards to the other things that you brought up, I believe the court's actually ruled on almost all of those other things in the past, and that's the reason we're not relitigating motions been litigated before this court in the past. We're electing not to do that. I think I put in my discussion.
Challenges the integrity of the some Judge Kephart due to their embezzlement and whatnot. So
they already have been, Mr. Secretary. That's what everyone has been saying.
not
They have. I'm not going to go back and forth with you. Ultimately, that's my ruling, is that most of these things you brought up have been, almost all of them, 99.9% of them have been litigated, either in front of me or in front of different judges, and they're not ready for reconsideration at this time. We do have a 9-3 calendar call and a 9-9 make sure that things are ready to progress, or we'll see where we're at.
So, Your Honor, are we because that question still remains. So it has been agreed to follow through.
We'll talk about it on August 6th. All right, thank you. Next matter. Pages 2 through 6, Raven Queen, Antonio Washington, Gonzalo Lee, Howard Cadell, Lamonte Butler, C37148.
Great, how are you?
How's the new home?
All right, can I get everyone's appearances?
Good morning, Honor. Tom Erickson, and last meeting on behalf of Reverend Sweeney,
Address the floor, Attorney, on behalf of the President.
Jeff Nicholson on behalf of Mr. Cabot.
John Green on behalf of Mr. Washington, Your Honor, he is present in custody.
And Lance Center on behalf of Denzel Lee, in custody.
All right, this was on for, initially it was a calendar call, but everyone let me know that it was not going to be prepared to proceed due to the large amount of discovery in this matter, as well as the fact that Mr. Klaus was moving on the case. So although Mr. Klaus did file a motion to continue, I believe that's already been ruled upon, and I determined that there was enough presented to me to provide good cause to continue the case. I then requested that everyone meet and confirm a couple trial dates so that I wasn't just shouting trial dates out into the abyss. Has that been done?
Your Honor, yes, we started an email chain.
All right.
It's looking like everyone's got an agreement into 2025.
All right.
Late February, early March, or late April through May.
And Judge, I was looking at my schedule, I just did a double take. I do have a trial at the end of February, so perhaps the April time is the court.
All right. April 14th?
That's
That's what your attorney just said. He was
I can't do
possible.
that April, Judge. I'm out of town 14th to the 20th. So I say late April or early May, or any time in there.
April 28th?
Just gotta look to the state.
All right, April 28th at 9 a.m. with counter called April 20th.
I know I have a
That'll be our dates for that. Did you want to do, anyone want to do a status check for, yes, November? Do a status check November 12th on trial readiness, 9 a.m.
November 12th is fine with President Washington, Your Honor.
Perfect. And then I think everyone else is addressed, except for Mr. Claus has outstanding motions.
Yes,
Anything
Your Honor.
else from Mr. Erickson or Mr. Benito? Anything else on behalf of Mr. Green?
No,
Mr.
nothing,
Green
Your
on
Honor. Thank
behalf
you so
of
much.
Washington? Anything else, Mr. Lee? Anything else for Mr. Cabot? Okay, you are free to go. We'll then move on to Mr. Waller.
And Your Honor, if I can, but the state filed their opposition on the 22nd, I will file a reply. It won't take much time. Plus, I'll have some help next week when I'm open. So we can just move this to 1 week and I'll reply to file.
Let's do the 7th. Sorry, what's the first? Let's do the 9th at 9 a.m. for our. All right, we'll see you guys back at that time. All right, so we're back on Mr. Blal's hearing on behalf of the state. This is on for a source hearing regarding the bail. Just one quick thought. Mr. Arnold, I know you weren't here at the time of the bail setting. And so ultimately the reason I set this, the purpose of the source hearing was because of the peculiar procedural history of this case and the facts here was really to ensure that the bond is not posted with proceeds from talking about the murder or killing of Mr. Shakur. And so that's sort of been the focus of this source hearing, as well as obviously, legitimate funds. And so I did get the materials that you sent forth.
Okay.
So how do you want to proceed with the source hearing and knowing that?
Your Honor, I believe that we have Mr. Jones. He's prepared to testify, answer any questions that the state may have. I submitted to them the same packet that you have, Your Honor, and they expressed to me they want to make sure under oath that he's not going to benefit from the proceeds in any manner. I don't believe there are any other financial questions. If there is, they won't brought to my attention.
So yes, Your Honor, the state
would like to question Mr. Jones under
So I'll then have him placed under oath. I'll let Mr. Arnold ask him a few introductory questions, or whatever questions he wants to get out. I'll allow you to have cross-examination, and I may have some questions as well.
All right, and yes, Mr. Okay.
Okay, Mr. Arnold, do we have Mr. Jones? I think Cash Jones, I see him on. Sir, if you could unmute yourself.
Yeah, I'm not muted, just gonna let me come off camera.
Okay, do you have a camera that you can turn on at this point, or it's not Lamara?
What it says the host has, you cannot start the video because the host has stopped it on the
Okay,
camera.
let's see if we can get that fixed.
Okay, there it goes.
All right, so we've got Mr. Jones. Are we able to make him the largest person? Yes, I am. Perfect. All right. Mr. Jones, we're going to place you under oath.
Please raise your right hand. You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the help you God.
I do.
May I please have you state and spell your first and last name for the record?
Cash, C-A-S-H, Jones, J-O-N-E-S.
Thank you, sir. Mr. Arnold, you may proceed.
Thank you, Your Honor. Mr. Jones, what was the amount that you paid for the bail bond premium in this case?
$112,000. It was 15% of whatever 750 was.
Okay,
$112,000 and some odd dollars.
$500, is that correct?
112.5, yes, sir. Yes, sir.
And you paid that out of your business?
Yes, sir.
And what's your business name, sir?
100 Entertainment.
And you're the sole owner of that business, is that correct?
Yes, sir.
And that business is a business license to do business in the state of Nevada.
Yes, sir.
And how long have you had that business?
Roughly 8 years, maybe.
And again, you used the proceeds from that business and you provided us with the documents showing that those amounts were taken from your business account. Is that correct?
Yes, sir.
How do you know Mr. Davis, sir?
I know him through passing. I know his son. I know him. We sat down, we talked a few times. In general, about personal things. He was having this bout with cancer, and personal things, industry stuff. Just regular conversation. He's always been a monumental guy in our community. Conversation. So and I've helped several people in our community, whether it was funerals, whether it was for bail. In this situation, I know his cancer has been. I don't know if it's come out of remission, but within speaking with his son, I know he's having an issue in there, so I'll let the help in hand.
We appreciate that, sir. Sir, are you deriving any benefit financially from Mr. Davis's release?
I know I'm not.
All right, I have no further questions, John.
State cross-examination.
Yes, do you need me to stand at the podium because of the blue jeans aspect, or sir, you're in the entertainment business, is that right?
That's one of my businesses, yes.
Sure. And you also go by the moniker WAC 100.
Yes, I do.
And one of the things that you do is manage, some artists like The Game and Blueface, etc.
Yes.
And where do you live?
I have a residence in California. I have multiple residences in California, Oklahoma, as well as New Jersey and New York.
Okay. And is it fair to say that the last 4 digits of your phone number are 6979?
6979.
Okay. All right, I want to turn your attention. We were provided a letter by Mr. Arnold that said that you had known Mr. Davis and his family for many years. Is that right?
I mean, you know, they're a pillar of our community, especially the urban community.
Well, I think let me clarify. You said, I have been a good friend of Mr. Davis and his family for many years. Is that right?
Well, I know his sister, I know him, I know his son.
When did you first meet Mr. Davis?
Oh. In passing, maybe about, I don't know, 8 years ago, maybe.
When did you become good friends with Mr. Davis?
Good friends with a lot of people.
I'm sorry, when did you become good friends with Mr. Davis?
The day I met him, the day we shook hands. You know, we come from our upbringing, we come from the opposite sides of the track. So, in my travels over the last 25 years, of coming from the gang life and making my exit from being a gang banger, anybody that I meet that's willing to sit down with me and be cordial and be respectful, I'm going to consider a good friend.
All right, and so the other thing you say in the letter that Mr. Arnold provided to us is that the money is a gift and Mr. Davis is not obligated to repay. Is that right?
That's right.
All right. Do you have any contract between you and Mr. Davis?
Not as of yet.
Okay. Do you have any financial agreement with Mr. Davis?
Not as of yet.
Do you have any financial agreement with his son?
No, I don't. I've offered him to come work for me. That's what he wanted to do, to try to get him out the streets.
Now, so are there any stipulations that you have with Mr. Davis in order to put up this money for him?
Well, my stipulation with the bail bond, I definitely wanted him to be on house arrest to protect myself.
Now, have you ever said you were thinking about getting Mr. Davis out with the stipulation that you do a series with him?
We've had talks and conversations just about what would be a series, as the BMF series, and just in question, in general conversation, talking about his life story. But I'm not in TV land, I'm in music. I don't do TV.
Okay.
I've never done a television show or any of that. I do music. Music, streaming, diapers, stuff like that.
Okay, so I just want to be very clear about this. Have you ever stated that you planned on getting Mr. Davis out as long as he did a stipulation with you to do a television series with you?
Oh, I have said this story would be a very interesting story. As if Orlando Anderson's story would be a very interesting story. As if the BMF story, as if my story. We talk about it, everybody talks about it, but again, that's not my lane. If that's what he chooses to do, then that's what he chooses to do. That's not what I do.
And you had mentioned earlier, you had agreed with me earlier that the last 4 digits of your phone number were 6979, correct?
6979, yes.
And you've had at least one conversation with Mr. Davis via jail calls, is that correct?
One call, yes. I spoke with him one time.
And as part of that time, you asked Mr. Davis whether or not he had signed the contract, is that right?
Yes, I did.
What contract was that?
His life rights contract. Somebody told me he had did a life rights deal, and I was asking them why didn't they come assist him.
And so you didn't ask him to send you his waiver of his life rights to you, have you?
No, I mean, at the end of the day, again, that's not my lane. That's not what I do. I do music.
And I'm gonna have to play some exhibits later, Your Honor. But in terms of if someone were to say that this money put up is not entirely for you, would that be the truth or a lie?
Say it again.
If someone were to say that the money provided here to bail Mr. Davis out is not from you, would that be the truth or a lie?
Be a lie.
Okay. If someone,
I didn't send the money, is that what you're saying?
yeah.
Saying I'm not the one providing the funds?
Yes.
Yeah, that would be a lie.
If someone said you are being used as a front, would that be the truth or a lie?
That would be a lie.
If someone says you are a middleman in this transaction, would that be a truth or a lie?
That would be a lie.
If somebody said that there's a movie company putting up the money for you, would that be a truth or a lie?
What company?
A movie company.
No, that would be a lie.
Okay. So your testimony is you're not
I'm not a what?
a middleman.
No, I have no contracts for any movie companies. I've never had a contract with a movie company. I've never done television. It's not my thing. I'm actually moving out of entertainment into the diaper business. I have a company called Incredible Diapers. I have contracts in Congo, Nigeria, Amazon, Walmart, and whatever. So I'm really moving away from entertainment. These are things I can provide documents, MOUs, contracts for.
No, and I appreciate that, Mr. Jones. Your Honor, I think I'm going to have, I don't know how mechanically we want to do this. I have a video featuring Mr. Jones talking about the stipulations that he would require.
Let's do the interview.
Yes. And then I also have a couple of jail calls talking about signing a contract with Mr.
You just play them, and then they will play both from your computer, and they will play through the speakers.
I think for this witness in particular,
have you ever met KPD?
I'm going to stop it for
You know,
a second.
person? Yeah.
Do you want to authenticate that?
it's going to be
Live TV interview.
Yeah, so you agree that you did a Vlad TV interview, is that right?
I work for Vlad. I'm contracted to go to Vlad. I go there like every 2-3 months.
In fact, you did one about a month ago, is that right?
1 or 2 ago, maybe something like that. Yeah.
Okay, and I think Mr.
About
Arnold,
about 2-3 months ago. Yeah.
I think Mr. Arnold will stipulate that the person depicted as WAC 100 is Mr. Jones.
Right.
Okay. All right, so I think we have foundation for the Vlad interview for 21. You may play it.
His lawyer did an interview recently and said KPD is a liar. He made up all this stuff just to make some money for people like, me for interviews and to get out of a serious drug case. He was never in Las Vegas. All this is fake. And he's not connected to Tupac's murder at all. Yeah, I believe him. You believe him? Do I believe him? That's up to law enforcement. That's, I'm not going to say. That's up to law enforcement. Let me go home in the next 5 to think about going to bed or not. You going to bail out KPD? Yeah, it's only 75. Well, because the $1 million bond is 750. 750, so you got to put 75. Yeah, I've been thinking about going to get him, and put the stipulations that I do the series on it. People are watching. Yeah.
Mr. Jones, did you hear that interview?
That's the interview.
Yeah, and it's fair to say that.
Do you understand, Brian?
Wait, sir. You can answer my questions. I'm sure Mr. Arnold has questions for you. You can answer those. So it's fair to say that you said you would bail Mr. Davis out as long as he follows some stipulations, correct?
Well, it's just entertainment with Vlad.
Sir, my question requires, sir, my question simply requires a yes or no answer. Did you tell, or did you say that you would bail out Mr. Davis, assuming he follows some stipulations?
With Vlad, me and Vlad discussed that.
Okay,
We was going to say that. We discussed what we're going to do before we interview. Now, everybody knows that about Vlad.
And in fact, you said that you would bail him out in return for an agreement to do a series on Mr. Davis's life, correct?
That's what I said to Vlad, but TPD is already involved with somebody. With that, I believe, with his book. I have no contracts with him or no dealings with him on that.
Okay, so you're saying what you said there is just not true.
We have, before you go on Vlad, you have a discussion about what you're going to talk about, what needs to be said so we can drive the views,
nothing about Vlad or nothing about YouTube that says that we're being truthful about what we're saying, we're entertaining. I'm just, being truthful, which I do a lot of interviews. I do interviews every week on No Jumper, and we sit there and we BS about things and we exaggerate things or we make up things. But it's a view thing. They pay you for that.
Okay, so you are exaggerating or not telling the truth when you're on Vlad TV.
I mean, you see the number I gave wasn't accurate. If I was gonna, that's what the conversation was, I would have gave you the accurate number if that's what it was.
All right, Your Honor, at this point, I would like to publish a jail call between Mr. Davis and Mr. Jones. It's from, sorry. In order to protect Mr. Jones' privacy, it's just the last four digits are 697.
No. Oh, excuse me. My last four is 6979. He's never called me direct. Somebody's always called me for him.
So we agreed your last four are 697, correct?
No. My last 4 or 3, what are we saying? Because my last 3 is 979.
Yes, we agree with that. I'm going to publish a call between Mr. Davis and Mr. Jones.
Okay.
What up, man? Take that home? Yeah, I can help you out of more. I can get work. I've been on this board, yeah. That's playing last week. With the coach, I should go through the daddy and get him. Stop playing. Yeah, I've been doing all my due diligence. I've been setting things up so we can get right to it. Once you come home, niggas got to string the things out. You know what I'm saying? And that gives us time to set up. Because my family didn't fuck the movie shit. Take too long. We can do that later. Let's do the series. You know what I'm saying? We got like 30, 40, we got like at least 30, 40 different episodes with like 3, 4 scenes. Let's start with you. As a dude, the teenage years, show, the garage, local TV. No, it's cool. We can fucking finish. I'm telling you what my idea is, right? And, we can get these first 10 episodes done. We're gonna like put it forward and like, hey, get out doing that because we hate that, and so we gotta tie it to the name so we can make sure we perform. You gotta remember, this shit can set you up for the rest of your life. Even after you do what you do, it's a life thing. This is got you out the whole world forever. So let me tie in to these big wigs while they got pumped up and amped up, and to attach the right names to it. And then at the end of the day, we got the book. The book is pretty much our guide. We turned that into script, TV script form to let us run out the back up. We could start in the first 10, get that first 10 done. By the time the season starts, when we do that or around that, we good. Say it again. Yeah, but now this ain't even about no views. This is about we don't do the same 115 years being arrested as how. Yeah, we ain't fuck on YouTube. You going? Yeah, I know that because you got that ED story, you got Lady Lane story, your story, Summer Day, Jeff Rowe shit. You got all kinds of shit up in there. So we got at least 30, 40 episodes. I'm doing my due diligence. None of the little people want to tell you they can, so I had to reach out in it and call my people. They read it, they called it in. If they did, I submitted your wife's address because I guess the DA said they want a house arrest you, which is like they get blue face the same way. So and they got to register the address. Yeah, they got to register the address. So I said that over there. I'm doing everything I'm supposed to do. I'm just waiting on another
Honor, I understand Mr. Davis is part of that conversation, is hard to hear, so I can provide a copy to the court. The court wants to hear, but particularly the last end, they're talking about whether or not Mr. Davis has signed the contract, and Mr. Davis confirms that he has signed the contract.
I'm gonna ultimately have you provide, a disc of all of your exhibits to the, yes, sir.
Sign the contract before you even, raided my house, all that stuff.
Not right now.
Okay.
State has another exhibit to play,
Are there any questions you wanted to ask?
but nothing for, Mr. Jones.
Okay, anything further for Mr. Jones?
No.
Mr. Arnold, any questions you want to ask Mr. Jones?
Yes.
Okay.
Mr. Jones, do you remember the conversation that you had with, Mr. Davis by jail phone?
Yes, I do.
And can you tell us in regards to the conversation generally, what were you all discussing?
Well, the bondman was having a troubling time getting a hold of the wife. And unless they had a home he can go to for house arrest, they wasn't moving. I also had discussed with DVD that if I can read his book, right? And that upon him coming home, if he comes home, we can go over his book and some things that could be done, and we'll do those things. At the time, everybody has to realize is that I wasn't given any instructions on, I couldn't have an open conversation with him. Open conversation is open conversation. Something that hasn't been done is something that hasn't been done.
Okay. And in that jail phone call, it talks about something about a contract. Did you and KPD have any contract?
What it was TPD had a vehicle, a very long vehicle, that I was trying to get to, and it's on the East Coast. There was some titling problems. I found the owner of the vehicle. That guy told me what I needed to do if I wanted to obtain this vehicle. So our conversation is all over the place in there. At the end of the day, I don't do television. Is it something that I may look into one day? Possibly. I have artists that have a history. But as of today, right now, as we sit, I have no contract with him. I have no television deal with any network. I'm a business guy, so of course it was a thought. But a thought versus being with the legitimate businesses is two different things.
Do you have anything in writing that states that you will derive any benefit from KPD's release and his story?
No, I don't.
It sounds like eventually you and KPD may sit down and have a conversation. Was that the intent of that discussion?
That's exactly what it is. I can plant a seed. I planted seeds. It took 10 years to grow. But positioning yourself for the near future, that's how I conduct my business. What it is today, there's no business today.
Right. And then in regards to the conversation that you have with Vlad, who's Vlad?
Vlad is a podcast guy. He's a blogger. We all are bloggers. I blog every week. I blog every Thursday on No Jumper. And it's a shame that the world takes what we blog about as if it's real. Like it's things that about me on the internet, down to fights that's not me fighting, and they say it's me. So, at the end of the day, it's astounding to me that a blog could be admitted in court when it's just that. It's just entertainment.
Well, I think
playing a role.
I think the purpose of them introducing it into evidence was that the statement in regards to stipulations, if he was to receive $75,000, which was not the bail amount, what were those stipulations? Prior to your interview with Vlad, did you have any stipulations that you had entered into with Mr. Davis?
I hadn't even talked to Mr. Davis. So again, it was just a blog and interview that I had. I hadn't spoken to him since he had been arrested. So it was just me talking. He asked a question, I built on the question. When you gotta sit there 2-3 hours, you stretch your conversation, you say whatever you gotta do to keep the back and forth going on. That's what it is, no more, no less. And at the end of the day, maybe these people should start telling us you're under oath of everything you're about to say, because before we go in the room, they say, hey, let's go in here for the show. And that's what we do.
One last question. I believe it was in the Vlad interview, and additionally, you made mention of it today. Did you become aware of Mr. Davis signing some life rights away in regards to his story?
Individuals told me this. I don't know if it's true or not. Somebody had told me, I guess, where he did the book with. I believe the book's been published for, I don't know, 3 to 5 years. I couldn't tell you. I had anything to do with it, but they had told me maybe whoever had something to do with the book had something to do with it. I don't know. I haven't really looked into it.
So you haven't seen any documentation in regards to Mr. Davis signing his life rights away, but you were made aware of that prior to going ahead and giving up this bail money. Is that correct?
That's correct.
And again, you're giving up this bail money in a hope that maybe you can have a sit-down conversation with him and discuss a series or something like this.
When it's all said and done, because the outcome of the situation is really what's going to dictate it. You know what I mean? I believe Mr. Davis is innocent, but if the outcome of the situation shows something any different, and then he's confined, and he is guilty of what they say he's guilty of, then it changes the whole scenario. But if the man is innocent, then, you know, why not? And at that point in time, there's no stipulations on it.
And so when you say the outcome of the situation, if you had any deal with Mr. Davis, this would be a deal that would be done after the completion of the trial.
But it would have to be. You couldn't go no other way. You couldn't go any other way, because if he's guilty, then it's like he's going to be looked upon a certain way. If he's innocent, as I think he is, as I know him to be, understanding the case, and he'll be looked at a total different way. And then, yeah, he deserves the right to have somebody that will do some business with him.
I have no further questions, Your Honor.
Anything further to say? Mr. Jones, I'm just really confused. What is this contract for? Obviously, there's a contract that you guys are talking about. Obviously, there's a contract based not only on your Vlad interview, but based on the jail call. So what is the contract for?
What contract are you referring to?
The contract that you're talking to him about.
2 or 3 months ago, I hadn't even spoken to Mr. Davis.
Okay, so what is the contract that you and Mr. Davis are talking about? What's it for?
The possibility of, upon his completion of trial, right? And yeah, we could talk about doing some television or doing something like that, but you know, as of right now, there's no business, there's no nothing. You know, hopefully, I don't know him to be guilty. I mean, innocent. I don't know him to be guilty. I mean, the people that we know that committed this crime are no longer with us. You know, I come from that. So, at the end of the day, I just think he has a better shot of representing himself, walking into the courtroom in a suit and tie and being healthy. The man has cancer, 60 years old with cancer, and you know, I know this to be true. So, you know, that's just really my disposition. If he was come out innocent, like everybody else that has came out innocent and did something after the fact, so be it. At that point in time, he's not under any stipulations, nor would I be. But at this present time, you know, I guess you could say, you know, maybe I got faith in this man. I got faith in the man. You know, I've been in these courtrooms before, bailing out other people. It's not the first time I posted bail for somebody out of Nevada court or a California court.
All right. Nothing further. Say, or Mr. Arnold, is there anything else you wanted to present?
Nothing further, Your Honor.
Okay. Mr. Jones, you can, if you want, you can stay on and see what happens, but you're not under oath anymore. You don't need to answer any more questions. State, did you want to present any more evidence?
Yes, Your Honor. We have a recorded jail visit between the defendant and Ms. Clemens, where
His wife.
his wife.
Okay.
Where I had asked Mr. Jones whether or not he was a middleman or a front, somebody else putting up the money for him. And in that visit, precisely what Mr. Davis says is that Mr. Jones is a middleman, that the money's not from him,
Okay.
that there's somebody from the movie putting it up. All right. This visit is from June 14, 2024.
Excuse me, ma'am.
Hold on. You have your chance, Mr. Davis.
I'll obviously submit all
We're to
these.
the state's presentation. So are you asking to reserve to something for rebuttal? Or?
No, Your Honor.
Okay.
So, again, as the court asks, I will submit all these exhibits to the court. But in the file of the visitation, I'm going to start at about, for brevity's sake, I'm going to start around like 9 minutes and 30 seconds.
The man name was Al Billickman, and he said that Rick said, they said that I lived there, Well, when Cash ain't got no damn money, you can just a man. Listen. Let me finish. Listen. Good.
So that's just 2 minutes, Your Honor. I think that, without belaboring it, there's more conversation along those lines. I can submit the whole 45 minutes to the court, but the essence of that, and I don't know if it came as clear, but it is Cash and Mr. Jones. First name is Cash. Cash doesn't have the money to get me out. Cash doesn't have the money. And using Mr. Davis's words, the Jewish man that owns the effing movie company, he's the one putting it out. You think he, meaning Cash, got that money to put up for me? He don't, Paula. He don't got that money. They just using him as a front. He was on to say a couple of disparaging things about Mr. Jones after that, but not particularly relevant to this proceeding. That's the state's presentation.
All right. Mr. Jones, is there anything else you wanted to address at this time? I think your client just wants to speak to you.
Yes, Your Honor. I just have some questions to Mr. Jones that I'd like to clarify that conversation, but if I can't speak.
Who do you want to talk to? Mr. Davis?
First to Mr. Davis, and then I'll ask the
all right.
questions.
I'll call a couple matters and let you talk to Mr. Davis, then we'll recall it as soon as you get those answers. All right, who wants to be called? Any quick matters?
Because we're really great.
Oh, I think Mr. Weinstock beat you to it, but
He's got a bigger smile. He can go first.
I'm quick, Your Honor. I have Mr. Hunter.
15, Malik Hunters,
Just
6795.
outright. I've never seen something like this.
Mr. Hunters, present in custody. This is on for trial setting. We have Ms. Worship from the state. Would you guys discuss trial?
Not necessarily. It's going to have for whatever is being the board for the ordinary court.
You don't really have to, on the homicide, but if there is an ordinary course, the soonest I have is August 12th, and then it goes into November, and after
It would have to be sometime next year for us.
January 27th, does that work?
Yes,
All right, we're gonna do January 27th, 3800 IM, counter call of January 21st, also 9. And then we'll do a status check to make sure you've got all the discoveries, running well with everything. See that. Do I have Mr. Singer?
Mr. Singer's been with, appointing counsel's office, took a month.
That's what I wondered.
Apparently, there was some mix-up with who got appointed or something like that. It's supposed to put the SPC
Can you
first.
approach? Yes. Let's do that.
hold on.
Ms. Dunlop, there's just some confusion about your attorney, because you guys are in a vote, and because it looks like Mr. Vanderbeek is indicating that he's gonna be ready to go on the 8th, we have a vote setting. I'm actually just gonna pass this over for a special set on Thursday, which is gonna be the 27th at 9 a.m. That'll be just this case, both Ms. Don Juan and Ms. Gray. I'll talk to Ms. Bush to see what's going on with your attorney, and so hopefully we can maintain the date that we currently have, because you guys are in both. I want to respect that, okay? All right, so continue till Thursday. We'll see everyone back at that time.
I'll be here, Judge. Thank you.
Did anyone else have anything real quick they wanted to say?
Your Honor,
Mrs.
I have an address, please.
You have a plate? Yes. Okay. I think I need somebody to stand in, correct?
Correct.
Okay, perfect. You're here on this one. All right, let's call Candelaria, page 12C380240.
Good morning, Your Honor. This is on behalf of Mr. Candelaria, who is present in custody at this time. Your Honor should have a filed guilty plea agreement.
Go ahead and state the negotiations for the record.
Your Honor, today Mr. Candelaria is prepared to plead guilty to 1 count of murder in the second degree use of a deadly weapon. The parties agreed to recommend 15 to life as the aggregate sentence on that charge.
Is that all correct?
That's correct.
Mr. Candelaria, is that your understanding of the negotiations?
Yes, ma'am.
What is your true and full name?
Elijah Robert Candelaria,
How old are you, sir?
18,
How far did you go in school?
11th grade, like the beginning of 11th grade.
But you didn't finish?
No, I'm still in school here.
Okay. Is it fair to say that you read, write, and understand English?
Yes, ma'am.
Are you under the influence of any alcohol, drugs, or medication today?
Ma'am.
Do you understand that you are being charged with second-degree murder, in this case, with use of a deadly weapon?
Yes, ma'am.
How do you plead to that charge? Guilty or not guilty?
Guilty.
Is anybody forcing you to plead guilty?
No, ma'am.
Are you pleading guilty of your own free will?
Yes, ma'am.
Do you understand that the penalty for second-degree murder is either 10 to 25 years in prison or 10 to life? You know, those are the two available penalties for that charge.
Yes, ma'am.
Do you also understand that the deadly weapon enhancement carries a mandatory consecutive 1 to 20-year sentence?
Yes, ma'am.
Do you understand that at the end of the day, sentencing is strictly up to the court or myself, so that nobody can promise you probation, leniency, or special treatment in this case?
Yes, ma'am.
You got that? Okay. And I do have a copy of your guilty plea agreement. In this case, it looks like on page 6 you signed this document. Did you sign it?
Yeah.
Was that after you talked to your attorney about the case?
Yes, ma'am.
Did you go over the entire document with your attorney before you signed it?
Yes, ma'am.
Did she answer all your questions before you signed off on it?
Yes, ma'am.
Course motion.
Sure.
Thank you, Your Honor.
Okay. Did anyone force or threaten you in any way to make you sign off on this deal?
No, ma'am.
Do you understand you're giving up the constitutional rights that are listed in this document by pleading guilty?
Yes, ma'am.
Do you want me to go over any of those constitutional rights? Do you have any questions about them?
No, ma'am.
Do you understand that if you're not a U.S. citizen, this plea could result in negative immigration consequences to you?
Yes, ma'am.
Did you discuss your case and your rights with your attorney?
Yes, ma'am.
Do you have any question about your case or your rights for me?
No, ma'am.
Okay. The amended indictment reads as follows. On or about December 13th, 2023, you did willfully, unlawfully, feloniously, and with malice aforethought kill Noe Lopez Garcia, a human being, with use of a deadly weapon, to wit, a knife and or an unknown bladed object, by stabbing Noe Lopez Garcia in the face and or neck with said knife and or unknown bladed object, that killing having been either willful, deliberate, and premeditated, and or committed during the perpetration or attempted perpetration of a burglary and or robbery, and or committed after lying in wait. Are those the facts that cause you to plead guilty today, sir?
Yes, ma'am.
All right. I find there is a factual basis for this plea and it is freely and voluntarily entered. At this time, we will refer the case to the Department of Parole and Probation for preparation of a PSI and set it down for sentencing on the following date.
That'll be August 6th at 9 a.m.
All right. We're also going to
Your Honor.
vacate the calendar column.
I have the jurisdiction on this.
Did you want to move it 1 week back?
1 week back would be great.
So that'll be,
That'll be July 30th at 9 a.m.
oh, I meant the other way. Oh, sorry.
August 13th at 9 a.m.
Okay. Does that work?
Thank you, Your Honor.
All right. We'll see everyone back for that date. Calendar call of 7-9 and jury trial of 7-15 are vacated. We'll see you back for sentencing. Thank you.
Do we have anybody for a road viewing?
All right. They're going to download some? Ms. Mercer, do you have anything from Mr. Ewing on this matter, or are we still waiting for him?
I just have a text message and I have her back.
Okay. Let us know. There's just, some special combination you have to make for that one. Are we ready to recall Mr. Davis's matter?
Yes, Your Honor.
Okay. Recalling Dwayne Davis, page 16, C377407. Mr. Davis is still present with Mr. Arnold, and we have Mr. Jeffro and Mr. Kowal back. Mr. Arnold, how do you want to proceed with this time?
Probably have to put Mr. Davis under oath. I just wanted to answer some specific questions in regards to what we just heard.
Okay.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God. May I please have you state and spell your first and last name for the record?
Dwayne Keith Davis.
Could you spell it?
D-A-V-I-S.
And
Dwayne, D-U-A-N-E.
D-U-A-N-E? Okay, go ahead, Mr. Davis.
Okay.
Oh, Mr. Arnold has questions of Mr. Davis.
And Mr. Davis, you heard the conversation between your wife and you while you were in custody?
Yes, sir.
And when did that conversation happen?
This happened, I think the day of my birthday, June 14th.
At that point, was the bond posted?
No, sir.
What was the reason that your wife came down to have that discussion with you in regards to Mr. Jones and the cash
She said,
bond?
she said, I'm not signing no papers for, what's her name, you know, I don't like that.
And when she said that she didn't like him, who was she referring to?
Cass Jones, because her family has problems with it. I don't have problems. And she was like, you're punking that sellout, this and that. And that's what she said. And I was just telling her to throw her the fuck off, get her off my, excuse my friend, get her off my back. You know what I'm saying? I don't want to look like no wuss for her or her family, you know? And I'm selling out.
Let me ask a question. Did you think at that time in the bond process that your wife's signature was necessary for you to be released?
Yes, sir.
And so in the effort to convince her to go ahead and get her signature, what did you tell her in regards to Mr. Jones?
I said, he don't have nobody like that to put up. It's Jewish people, it's just so she can sign the fucking bond and leave, you know, leave that as is. She was saying I was a sellout. They played the whole tape.
Did you come to find out that you did not need her signature to enter into the bond process?
I found out just following Wednesday when he came up here and seen me.
And so any conversation that you had with your wife at that time was in an effort just to get her to comply with the bond process?
That's right. I wanted to go on because I got cancer, and I just called it back. In here eating y'all processed food. You know, I had colon cancer right here. And it's down in the wound to this side. Behind this processed food in there. They don't sell no fruit. They don't, it's just terrible. Fake potatoes, fake milk, fake everything. It ain't good for an ex-cancer patient. Now I got it again. They took me to the hospital, UMC, on the 5th of May. He came up to my cell and said, Mr. Davis, hurry up and get dressed. You need emergency surgery. So I went over there. They did all the CAT scans and stuff. And they referred me to my cancer doctor. So I went and seen him on the 8th of May. And he said, I'll get you to do a colonoscopy in a week, CAT scan in 2 weeks, a PET scan in 3 weeks. They haven't came here to do nothing. I'm in a life situation, and I would say anything to save my life.
So if there's issues with not getting that medical care and there's an order that you need or anything, we will sign that. There's no issues with that. What are you trying to get at with this information, Mr. Arnold?
No, he provided everything that we needed at this
Okay.
point, Your Honor.
Any cross-examination on these very limited issues?
Very limited, sir, so my understanding of your testimony is that you thought you needed Ms. Clemens' signature in order to get out of custody.
Yes, sir.
And in order to facilitate that, you lied to her.
Yes.
You're not under oath anymore? Mr. Arnold, did you want to talk to Mr. Jones any further, or are you good?
Mr. Davis? Mr. Jones? No, I'm good with everything.
Okay, let's, I guess, argument?
Sure.
Unless you have anything further to present.
Nothing further, Your
This
Honor.
has been a very unorthodox hearing, so I'm giving everybody an opportunity to be heard. Go ahead. Mr. Arnold, your argument regarding whether you've met your standard under the source hearing.
Your Honor, nothing has been provided to show that Mr. Jones, the person that is putting up the amount of cash bail as going to derive from this story. There's a hope at some point and at some time that he will derive from it, but there's no contract signed between him and Mr. Davis. The state hasn't produced any contract showing that. Additionally, the state is trying to say from Mr. Davis's own mouth that Mr. Jones is just a middleman. However, again, he had this conversation with his wife, as he explained, in an effort just to convince her to go ahead and sign whatever paperwork at that time that he was under the impression that she needed to sign. As he stated, in reference to myself, there was no paperwork that she needed to sign to proceed with the bail. No one at this juncture is deriving any financial benefit from his release. I'm sure there's hopes. To be honest, Your Honor, I get a call every other day in regards to, some kind of series or something that somebody wants to. We haven't agreed to anything. We haven't signed anything. We have a trial to prepare for. I need Mr. Davis out so I can prepare for that trial, and we can go ahead and be ready in November.
What we've learned today is that Mr. Jones is not credible when he says that he has no Mr. Davis retelling the crimes that he committed upon his release. The statement that he provided to the court, that his attorney provided to me, that this is a gift, is clearly not true. I mean, it's just out and out false. The interview he gave on Vlad TV says, I expect some stipulations. I want to have a television series out of this. So Mr. Jones's response is actually kind of similar to Mr. Davis's response when it comes to this case. Don't believe the words that are coming out of my mouth. It's just entertainment. It becomes even more problematic, though, when he has that same conversation with Mr. Davis on jail calls where there's literally nobody to perform. Says, as Mr. Jones says, we need to get some episodes in before you go to trial. We need to get 10 episodes done before you go to trial. And let's be honest, I mean, the only reason why Mr. Davis is of note at all is because of his self-proclaimed murder of Tupac Shakur. That is his notoriety. In Your Honor, I think the other thing, a couple of a prison visit, which is either A, jail visit, front, or B, he's lying, and he admitted he would say anything to include lie in order to get out of custody. Lastly, Your Honor, I was, the one advantage of having cameras in this case is that I'm able to review this court's rulings before coming to court. And
You can always review them.
Yes, fair.
We always said yes, I'm not hiding.
Yeah, no, but I get it in HD. And so what I heard this court say is that this court wanted a detention order. And this court specifically was concerned about the defendant's repeated insistence that he committed these crimes. And that this court found that while his criminal past may be somewhat removed, concerns still arose, including the FBI having to move a witness, about Mr. Davis's future safety, which is the reason why the court set the bail at $750,000. So let's just assume, A, it's a gift. That doesn't allay the court's concerns. How could found money, without any consequence of losing it, affect Mr. Davis at all? If he's being told by some benefactor, just for out of goodwill, I'm letting you out, go out, there's no consequence to Mr. Davis. It doesn't have the prescribed deterrence that this court's detention order had. Let's say, which I think the evidence clearly leads to, that this is him getting paid from his retelling of his criminal past. Well, I mean, pursuant to NRS 441B200, a killer cannot profit from their crimes. And what is even worse about this particular instance is that there was no way there'd be no way for the estate to recover these funds. Because Mr. Davis is getting a benefit from having retelling his story of killing Mr. Shakur. As a result, Mr. Jones, in order to benefit from that, is paying the bail bond company $112,000, right? The purpose of the statute in statutory scheme is that an estate should be able to recover the of their crime. Here, there's no way for the estate. I think what is abundantly clear from this thing, even though it's convoluted, is that a fraud is being perpetrated on us, one way or the other. I think if the court had an opportunity to question Mr. Jones, see what he said on Vlad TV, see what he said on jail call, see what Mr. Davis said in the privacy of that jail call. I don't think this court can have any faith that this surety, the source of this surety, is legal in the sense that it is for the benefits, the illegal benefits of profiting from his or her crime. And then, two, I don't think this court can even have any faith as to what this actual nature of this is.
Much more questions than answers. Ultimately, there's a question that by Mr. Davis himself. I don't have the bank records or anything to show that it was posted by a different source besides the word of Mr. Jones, who's contradicted by his own previous statements on other matters. Ultimately, I do see there was collateral posted, but I don't really see where the actual $112,500 came from with what's been provided for me. I also don't find that the defense has met the burden of any sort of burden, for the Nebula type hearing to show that the bail is not connected to Mr. Davis ultimately talking about Mr. Shakur's murder. And any evidence to the contrary, it is not credible. And so at this point, I don't find that you have met your burden. And so if you want, you can present additional evidence at some point if you want to have a further hearing, or I can void the bail, and so that would go back to Mr. Jones. So.
Thursday bank statements.
I don't have them.
The bail department is here. He's on the Zoom. I have to give up 6 months of bank statements.
We did send those over to the court, Your Honor. You didn't have them.
Showing you what I have.
It's going to show you that whatever you told me, it was definitely exaggerated back.
Mr. Jones, hold on.
I also turned in one of my properties.
Mr. Jones, hold on. We also sent the bank records.
Okay.
Sorry.
Okay.
You guys have
Do you have bank records?
Yes, Mr. Arnold provided, I think 6 months of banking records.
Okay.
Your Honor, I'm the bail agent. On this matter, I could testify if necessary on regards to the source of the funds.
All right, I'll review the bank records additionally, and then ultimately issue a minute order regarding the bank records if that satisfies my first concern. I don't know that it will necessarily satisfy my second concern, but I'll address it all in the minute order, okay? All right, it'll be under advisement. Thank you.
Thank you, Your Honor.
What do that mean?
Mr. Arnold can explain it to you. Ultimately, I have to review more documents to determine if that shows what Mr. Jones says it shows. Page 8, Kevin Perez Stubbs, C378339.
Governor, will you appearing on behalf of Mr. Perez Stubbs?
Okay, is Mr. Perez Stubbs? Yeah. This is on for